Hello, I'm David Roger, General Counsel for the Las Vegas Police Protective Association. I want to talk to you in this video and this next several videos about Miranda warnings. And we will talk about every aspect of Miranda, but I think a good starting point is to talk about the Miranda decision. Miranda versus Arizona is a 1963 U.S. Supreme Court case. And it dealt with the Fifth Amendment right to not incriminate oneself. And so here is the holding. The prosecution may not use statements, whether exculpatory or inculpatory, stemming from custodial interrogation of the defendant, unless it demonstrates the use of procedural safeguards effective to secure the privilege against self-incrimination. By custodial interrogation, we mean questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his or her freedom of action in any significant way. As for the procedural safeguards to be employed, unless other fully effective means are devised to inform accused persons of their right to silence and to assure a continuous opportunity to exercise it, the following measures are required prior to any questioning. The person must be warned that he has a right to remain silent, that any statement he does make may be used as evidence against him, and that he has a right to the presence of an attorney, either retained or appointed. The defendant may waive effectuation of these rights, provided the waiver is made voluntarily, knowingly, and intelligently. If, however, he indicates in any manner and in any stage of the process that he wishes to consult with an attorney before speaking, there can be no questioning. Likewise, if the individual is alone and indicates in any manner that he does not wish to be interrogated, the police may not question him. The mere fact that he may have answered some questions or volunteered some statements of his own does not deprive him of the right to refrain from answering any further inquiries until he is consulted with an attorney and thereafter consents to be questioned. So there are a lot of concepts in that brief holding from the U.S. Supreme Court. There have been hundreds of thousands of cases since 1963 interpreting and applying Miranda, but we're going to try to keep it simple. And so for now, just to understand that in order for Miranda to apply, the person must be in custody and you must intend to interrogate the person. If the person is not in custody, you don't have to read a Miranda. Likewise, if the person is in custody, but you do not intend to interrogate the suspect, you don't have to read Miranda. And so keep in mind as we go through this, to keep it simple, is that Miranda is two prongs. The person has to be in custody and you have to interrogate him. If you don't have one of those two elements, Miranda does not apply. Thank you for listening. Please subscribe to our YouTube channel. If you have any questions about criminal law matters or you need an attorney to talk about any legal issues, call me, and if I can't help you, I'll find someone who can. Thank you.